All right, we're live and about to read literally anything in the BARBRI Convisor mini review that's still there because a lot of the subjects have been removed. Prop this up so you can hear me. Okay, or not. Over the traffic. So, agency is the first thing in here. Introduction is that agency refers to the legal relationship whereby one person, the principal, manifests assent that another, the agent, shall act on her behalf and under her control, and the agent consents to so act. Creation of agency relationship. Agency is consensual. Not all contractual formalities are necessary to create an agency relationship. Capacity. Principal must have contractual capacity. A principal must, right? What I just said. Thus, the minor's appointment of an agent is voidable, and incompetence, and most unincorporated organizations cannot be principals. However, in many jurisdictions, partnerships and other organized business entities can be principals and appoint agents. Agent needs only minimal capacity. So far, what's important on this page is definitely the definition of agency, which is a legal relationship whereby one person, the principal, manifests that another person shall act on their behalf under their control, and the agent consents to so act. That's kind of the most important thing going on. Obviously, you need capacity, which is crazy that you can't have it necessarily with, minor, understandable partnerships, unincorporated organizations, business entities. Now, let's read. Agent needs only minimal capacity. One may be an agent even though he has no contractual capacity. If the agent has literally no mental capacity, he cannot act for the principal. Notice the difference. Capacity requirements. The agent must have contractual capacity, but the agent need not. So the principal must have contractual capacity, but the agent need not. Thus, a minor can be an agent, but not a principal. Disqualification of agents. An agent may be disqualified for representing both parties or failing to have a required license. Formalities is consent from both parties, and no consideration is necessary. A minor can be an agent, not a principal. So require consent. Now, consideration is not required. Remember that no consideration is required to establish an agency relationship. For example, one may agree to serve as an agent gratuitously and be saddled with the duties of the agent. Writing. Generally, no writing is required, but many states require writing when the contract the agent is to enter into with a third party is within certain provisions of the statute of frauds, most notably land transactions. Modes of creating agency relationship. The agency relationship, separate this. Can be created by an act of the parties or by operation of law. By act of parties. Parties may create an agency by agreement between the principal and agent, i.e., actual authority holding out by the principal, i.e., apparent authority or ratification. By operation of law, these are ways to create an agency relationship. So, estoppel and statute is another potential way to create an agency relationship. So, it's either acts of the parties or operation of law, including estoppel. An agency can be created through estoppel. Estoppel is virtually the same as apparent authority in that it requires third-party reliance on the principal's representation. Statutes creating agencies are usually designed to accomplish a limited purpose. For example, statute appointing Secretary of State as out-of-state motorist agent for service of process for damages arising from driving in state. Creation of agency elements for a valid agency relationship to exist. Check the following. So what did I just say? Estoppel and statute. So, those are generally designed to accomplish a limited purpose. The elements for creation of agency is literally capacity, consent, writing if required, consideration is not required. So this little chart right here basically explains everything I just read. Because in capacity, it says principal must have full contractual capacity and agent must have at least minimal mental capacity, consent of both parties, and writing, if required by the statute of fraud, equal dignities rule is what's written here. Besides that, which I don't recognize from any other reading. Consideration is not required. Rights and duties between the principal and agent. The agent's duties, in addition to any express contractual duties that the agent owes the principal, fiduciary duties of loyalty, obedience to lawful instructions, and reasonable care under the circumstances. So there can be express contractual duties, but there's also implied duties of loyalty, obedience to lawful instructions, and reasonable care under the circumstances, including duty to disclose all relevant information are owed, while a gratuitous and a compensated agent may owe the same duty of care. The measure of reasonableness may vary because compensation is a proper circumstance to consider. Principal's remedies. A principal's remedy against the agent include contract actions against compensated agents, tort actions, actions for secret profits, equitable actions for an accounting and withholding of compensation for intentional torts or intentional breaches of fiduciary duty. The principal may recover the actual profits or properties held by the agent, whether or not the agent's profit has caused the principal any loss. The principal may also terminate the agency prior to any termination or date of contract. So the word that they like to dance around using here is disgorgement. I'm going to write it in. Subagents. A subagent is a person appointed by an agent to perform functions that the agent has consented to perform on behalf of the agent's principal. Remember that not every person appointed by an agent is a subagent. An agent may another principal. In doing so, the agent does not delegate his own power to that person. Employees of a single organization are presumed to be co-agents, not subagents. Manager and store clerk are co-agents, as an example. Liability of the agent. An agent has absolute liability to the principal for breaches by the sub-agent. Duties. If appointed with proper authority, the sub-agent owes the principal the same duties as agent. The agent is unauthorized. He owes no duties to the principal, but does owe duties to the agent. Principal's duties. The principal owes the agent all of the duties imposed by their contract, reasonable compensation, so contractual compensation and reimbursement for expenses. The principal also generally should cooperate with the agent and not unreasonably interfere with the agent's performance. Remember that if the agency agreement is silent regarding compensation, the agent is entitled to reasonable compensation. Also remember that a principal generally owes no duty to compensate a subagent, even if the agent has authority to hire the subagent. Agent's remedies. A compensated agent has Usual contract remedies against the principal, but has a duty to mitigate damages. Also, an agent has a right to a promissory lien if any money due from the principal, including compensation owed for services. Real estate brokers contracts, non-exclusive contracts. Non-exclusive contracts generally entitle the agent to compensation upon his production of a ready, willing, and able buyer, even though the sale is not consummated. Exclusive contracts. Exclusive contracts enable the broker to get his commission if anyone produces a ready, willing, and able buyer. Oh, look, more charts. Principals do. Okay. So the first chart is about duties of the principal and agent. And the second chart is about will the agent's acts bind the principal. So for the duties of the principal and the agent, the principal's duties are compensation, cooperation, indemnity, reimbursement, and express actual duties. On the left side, on the right side, the remedies available to the agent is contractual remedies and possessory lien. The bottom half of the chart shows the agent's duties on the left of reasonable care, loyalty, obedience, and express contractual duties. The remedies available to principal on the right are contractual remedies if the agent is compensated, tort remedies, constructive trusts, action for secret profits, withhold compensation, and terminate agency. Contractual liability, agency power, actual and apparent authority. When deciding whether a principal will be bound on an agent's contract, it should first be determined whether the agent had actual authority. If she did not, look to see whether apparent authority was present. The most important of all agency concepts for bar exam purposes are those involving actual and apparent authority. A very high percentage of questions will require you to display your understanding of this area. Actual authority is authority that the agent reasonably believes she possesses based on the principal's dealings with her. It may be expressed or implied. Express authority is that which is actually contained within the four corners of the agency agreement. It is effective even if it was granted mistakenly or because of misrepresentation. Implied authority is that which the agent reasonably believes she had as a result of the principal's actions. It includes authority incidental to express authority. 1, 2, arising out of custom known to the agent. 3, resulting from prior acquiescence by the principal. 4, to take emergency measures. 5, to delegate authority in cases of ministerial acts where circumstances require, where performance is impossible without delegation, or where delegation is customary. 6, to pay for and accept delivery of goods where there is authority to purchase. To give general warranties as to fitness and quality, and grant customary covenants in land sales, collect payment and deliver where there is authority to sell, and 8, to manage investments in accordance with the prudent investor standard. So those are the 8 implied authorities that arise when the agent reasonably believes they exist based on the principal's actions. And keep reading about these authorities, but return to that table. Actually, very interesting. The table on page 5 is relevant to the information on page 9. So, will the agent? I'm just going to read it now. Will the agent's acts bind the principal? It's a decision tree. You ask first: was there express or implied actual authority? Authority the agent reasonably believes she possesses based on her dealings with the principal. If yes, the principal will be bound to a third party by the agent. And if no, was there apparent authority? So the first question was actual authority. Now we're asking, inquiring if there was apparent authority the third party reasonably believe the agent has based on the third party's dealings with the principal. If yes, the principal will be bound. If no, the next question in the decision tree is, did the principal ratify the contract after the agent entered into it on the principal's behalf and before the third party withdrew? If the answer is yes, the principal will be bound to the third party. If the answer is no, then the principal will not be bound to the third party. So let's continue. We just finished talking about actual authority, express authority, implied authority, the 8 kinds, and then termination of actual authority. If you have determined the actual authority is created, you must then consider whether that authority has been terminated. How termination may occur. There are 6 examples here. Lapse of a specified or reasonable time, the happening of a specified event, a change in circumstances, including destruction of the subject matter of the authority, insolvency of the agent or principal, and a change in the law or business conditions, agent's breach of fiduciary duty. That's 4. 5, either party's unilateral termination, although such termination may constitute a breach of contract. Or 6, operation of law, the death or loss of capacity of either party except where a durable power of attorney, written authority that says it will not terminate on the principal's disability is present. So reminder 1, 2, and 3, lapse of specified or reasonable time, happening of a specified event, or change in circumstances, such as insolvency of agent or principal, or change in law, business conditions, subject matter, destruction of the subject matter of the authority. Bar examiners sometimes try to play on your emotions by making it seem unfair to terminate the agent's authority at the principal's death. Answer: with your head and not your heart. Death terminates an agency unless the agency is irrevocable. So an irrevocable agency is defined as neither an agency coupled with an interest nor power given as security may be unilaterally terminated by the principal if the agency was given to protect the agent's or the third party's rights and it is supported by consideration. Neither will such agencies be terminated by operation of law. All right. Can't even really think about an example to go to like the the only example I can really give is like when you've given an irrevocable like proxy to vote your shares in a specific way, and it's coupled with an interest, like for instance, like the person holding the proxy trust is also a shareholder or actually has title to the shares because you put them in trust. I don't know. But that might be an irrevocable agency. I mean, it needs to be coupled with an interest and supported by consideration. All right, so those are what you gotta remember if you come into an issue about it. Apparent authority, basic theory is that apparent authority arises from reasonable beliefs of third parties. If a principal directly or indirectly holds out another as possessing certain authority, thereby inducing reasonable reliance by others on that authority, the person so held out has apparent authority, even though, as between himself and the principal, such authority has not been granted. Be sure to remember that in an apparent authority situation, you need to discuss what transpired between the principal and the third party. This differs from an actual authority situation where you would be discussing what transpired between the principal and the agent. In discussing apparent authority, ask yourself what the principal did to indicate to the third party that the agent had authority. Yeah, I would actually ask about what the agent did to justify that they had authority. Types of apparent authority. When the agent has no actual authority, there are certain situations in which at the time the agent acts, he has no actual authority, yet the principal may be bound. Imposters, for example, lingering apparent authority, and those are the only two examples of when an agent has no actual authority. And the principal may be bound. So for imposters, where the principal negligently permits an impostor to be in a position to appear to have agency authority, the principal will be held liable for the impostor's actions undertaken with such authority. Lingering apparent authority, as notice may be necessary, where the agent's actual authority has terminated, he will have apparent authority to act on the principal's behalf as to all third parties with whom the principal knows he dealt, unless and until the third parties receive either actual or constructive notice of the termination, writing manifesting authority. Where an agent's actual authority has been terminated, but third parties rely on a written authority of the agent's apparent authority is not considered to be terminated. And death or incompetency, the majority view is that the death or incompetency of the principal does not automatically terminate the agent's apparent authority. When the agent exceeds, and so those are the three components of lingering apparent authority. When an agent exceeds actual authority, there are situations where the agent exceeds his authority, yet the principal is still bound. So prior act is where the principal previously permitted the agent to exceed his authority and knows that the third party is aware of this. The principal is bound by the agent's unauthorized act. Position, where the agent is in a position that customarily carries with it certain responsibilities. The principal is liable for the agent's acts that come within the customary responsibilities. A general agent has considerably broader apparent authority than a special agent who is engaged in specific transactions rather than continuity of service. Inherent authority, inherent agency power. Inherent authority is derived solely from the agency relationship and results in the principal being bound, even though the agent has no actual or apparent authority to perform the particular act. This occurs because agents wish to protect innocent third parties rather than the principal who gave some actual authority to the agent. Examples of inherent authority include respondeat superior, and conduct similar to that authorized. So under the doctrine of respondeat superior, the principal is held liable for the torts of her employee committed within the scope of her employment. Conduct similar to that authorized, where an agent exceeds his actual authority, he violates i.e. violates orders, but the conduct is similar to acts authorized, the principal will be held liable. C, improper disposition of goods. The principal will be held liable for the disposition of her goods by an agent possessing them if the agent was given some indicia of ownership or if the goods disposed of were sold by the agent who is a dealer in the particular goods. Wow. It's a huge jet. God, it's so enormous jet in the sky. Okay. Ratification actually is the next section. Effective ratification, prerequisites of ratification, and methods of ratifying, such as what may be ratified and by whom, are all discussed before we get to liabilities of the parties. So an agency relationship is created by ratification when an agent purports to act on behalf of a principal without any authority at all, but the principal subsequently validates the act and becomes bound. Ratification gives the transaction retroactive effect unless the principal lacked contractual capacity at the time the agent entered into the unauthorized transaction, in which case the principal is deemed to have adopted the contract, or unless retroactivity would interfere with intervening third-party rights. Upon ratification, the agent is relieved of liability for breach of duty and his implied warranty of authority. This massive jet's coming back around the Angel Island or something. Okay. Adapted the contract or unless retroactivity would interfere with intervening third-party rights. Upon ratification, the agent is relieved of liability for breach of duty and his implied warranty of authority. That thing comes back. I hope I get it on camera. Prerequisites of ratification. For ratification to occur, the principal must know or have reason to know all material facts except the entire transaction, have capacity, be competent, and of legal age. Ratification is a unilateral act of the principal and requires no consideration. Methods of ratifying. Ratification may be expressed or implied through the conduct of the principal. Such conduct would include acceptance of the transaction's benefits, silence if there is a duty to disaffirm, and suing on the transaction. Oh, there goes the second head. Doing circles around Chloe. My face get in the way of that? Oh my god. Alright, maybe that thing will come back. I just read methods of ratifying, right? Ratification may be expressed or implied through the conduct of the principal. Such conduct would include acceptance of the transaction's benefits, silence if there is a duty to disaffirm, and suing on the transaction. Go down. What may be ratified and by whom? Generally, a principal may ratify anything unless 1, the performance was illegal at the time of ratification, 2, the third party has withdrawn, or 3, there has been a material change in circumstances. Under the second restatement, which is followed in most states, an undisclosed principal, that is one whose existence and identity is withheld from the third party, may not ratify. Only disclosed or unidentified principals may do so, but the second restatement requires that the agent purported to be acting on behalf of the principal. However, the modern view of the third restatement does not require the agent to purport to be acting on behalf of the principal. Therefore, under the third restatement, any principal may ratify. Note A. Yeah, that's what a real airplane looks like way up there. As opposed to this monster that might come back around. This way. That's real. The one over here. Oh, yeah. What was I saying? May do so. Okay, the third restatement does not require any agent to purport to be acting on behalf of the principal. Therefore, under the third restatement, any principal may ratify. A purported agent may not treat the contract as his own. Liabilities of the parties. Third party versus principal. The principal will be liable to the third party on a contract entered into by her agent if the agent has valid authority to act. This going away. Third party versus agent. The agent's liability depends on whether the principal is disclosed. Disclosed principal. A disclosed principal, existence and identity known to the third party, is always liable on the contract, and the agent generally is not liable. Exceptions. An agent is liable if the parties to the contract intended the agent to be liable, and an agent may be liable to the third party under his implied warranty that a principal with contractual capacity exists and that he, the agent, had authority to contract for the principal. Unidentified and undisclosed principals. An unidentified principal, one whose existence is known but whose identity is withheld, or an undisclosed principal, neither identity nor existence is disclosed, results in liability for both the principal and the agent. The majority of courts permit a third party to file suit against both the principal and the agent, but upon objection of either defendant, the third party may elect prior to judgment which party he wishes to hold liable. If the third party obtains a judgment against the agent without knowledge of the principal's identity, he can later sue the principal when her identity is discovered if the judgment has not been satisfied. Remember that the type of principal, disclosed, unidentified, and undisclosed, is relevant only when you are considering whether the agent is liable. Do not discuss the type of principal when analyzing the principal's liability, or whether, any type of principal will be bound as long as the agent had authority. Third party liability to principals and agents. So we talked about the third party versus the principal, the third party versus the agent. Now we're talking about third party liability to principal and agent. Disclose the principal situations. When the principal is disclosed, only the principal, not the agent, may enforce the contract and hold the third party liable. Unidentified and undisclosed principal situations. When the principal is unidentified or undisclosed, either the principal or the agent may enforce a contract and hold the third party liable. Note that if the agent enforces the contract against a third party, the principal is entitled to all of the rights and benefits thereunder. When principal may not enforce contract, the principal may not enforce the contract if there has been an affirmative, fraudulent misrepresentation of the principal's identity, or if there is an unforeseen increased burden to the third party due to the fact that performance is due to the principal and not the agent. So there's a table here on liability on contract, breaking it down into principal, agent, third party. For principal, they're bound if valid authority existed, apparent, actual, or by ratification. The agent is bound unless the principal's existence and identity are disclosed. Also can be liable for breach of the implied warranty of authority. And the third party is bound to the principal if valid authority existed. Now, to the agent if principal is unidentified or undisclosed, an agent enforces the contract with the principal entitled to contract benefits. So that's kind of all you really need to know and all I really took out of that. Furthermore, tort liability, vicarious liability of the principal and respondeat superior is really all we're going to talk about to close it out. In general, a principal may be vicariously liable for the torts of her agent under two theories, respondeat superior and two, apparent authority. Vicarious liability means that joint and several liability for the agent's tort may be imputed to the principal. The derivative nature of this liability means that if the agent is not liable, the principal generally cannot be held liable. However, an agent's immunity from a lawsuit does not necessarily bar recovery from the principal. Note that in addition to vicarious liability, a principal may be directly liable for her own negligence in hiring, retaining, and supervising the agent. A principal may also be directly liable for the agent's tort if she gave the agent actual authority to commit the tort or ratified the tort, or if the circumstances involving, or in other circumstances involving independent contractors. Yes, this is going to get. I have another page to go through this, another page and a half to go through this, but you can tell there's a lot of components. Excuse me. Like some crop duster or something. So we're going to go through each in turn, right? So starting with the respondeat superior, an employer-employee relationship is required to establish the liability of the principal under respondeat superior. First determination must be that an employer-employee, master-servant relationship existed. The scope of employment. Oh, there's missing pages. That's what happened. sugar. So for the missing pages, they're probably up on the wall, or could be around here somewhere. So this is a little bit, I guess, an expanded version. I don't really know. I have multiple versions of the same book, but I'm just gonna go. Okay, I'm just gonna read the more expanded version. So first we need to determine that relationship existed. The employer generally is not liable for torts committed by an agent acting as an independent contractor. Therefore, the first determination to be made in each case is whether, in fact, an employer-employee relationship did exist. And you need to determine this by considering whether the agent is an independent contractor or an employee. Independent contractors, a clear example of an independent contractor is one who has a calling of her own, is hired to do a particular job, is paid a given amount for the job, and who follows her own discretion in carrying out the job. A principal has no right to control the manner and method in which the independent contractor performs a job, whereas an employee, a clear example of an employee, is one who works full-time for his employer, is compensated on a time basis, and is subject to the supervision of the principal in the details of his work. An employer has the right to control the manner and method in which the employee performs the job. Determination of right to control. There are many cases where it is not clear whether the relationship is one of employer-employee or principal independent contractor. The single overriding factor is determining whether a person is an employee is whether the principal has a right to control the manner and method by which the person performs his tasks. Example is a case Community for Creative Nonviolence versus Reed. The following factors should be considered in determining right of control. Characterization by the parties, distinct business, custom regarding supervision, skill required, tool and facilities, period of employment, basis of compensation, understanding of the parties, and business purpose. So I could read what each and all of those are. Characterization by the parties. The way the parties characterize the relationship, employer-employee versus principal-independent contractor, is significant but not dispositive. Distinct business. Is the person hired engaged in a distinct business or occupation of her own? The person who has her own business or occupation is more likely to be an independent contractor. C, custom regarding supervision. What are the customs of the locality regarding supervision of the type of work to be performed? If in the locality the type of work involved is usually performed under the supervision of the principal, the relationship is more likely to be employer-employee. However, if in the locality the type of work is usually performed without supervision, the relationship is more likely to be principal-independent contractor. Skill required. What degree of skill is required in the particular endeavor? Where great skills required, an individual hired is more likely to be deemed an independent contractor. Or if only menial skills required. It doesn't say that, but tools and facilities. Does the worker or the principal supply the tools and facilities used to perform the job? If the principal supplies them, the relationship is more likely to be employer-employee. If the worker supplies her own tools and facilities, the relationship is more likely to be principal-independent contractor. And period of employment. What is the length of the employment period? If the period is definite and or short, the relationship is more likely to be a principal-independent contractor. If the period is indefinite and or long, the relationship is more likely to be employer-employee. Basis of compensation. What is the basis of compensation? If the compensation is on the basis of time, the relationship is more likely to be employer-employee. If the one hired is paid on a job basis, the relationship is more likely to be principal-independent contractor. understanding of the parties. Do the parties believe they've entered into an employer-employee relationship? Sometimes this is known by like if they have a contract and the contract like refers to them that way. Anyhow. Contract is right to control, where the contract gives the employer the right to control and is inclusive. Contract gives no right to control or is silent, where the contract is silent or specifically states that there is no right to control. Evidence regarding exercise of actual control may be introduced. Business purpose, last element I, was the person hired to perform an act in furtherance of the principal's business. If the principal does not hire the person for business purposes, for example, to mow the principal's lawn, then the hired person is more likely to be an independent contractor. Liability for acts of subservience. A principal may also be liable for the torts committed by a duly authorized subservient. In determining whether a subservient is authorized, you have to determine whether the person who hired him had authority to do so. A bar examination analysis should revolve around the existence or non-existence of such authority. Express authority to hire subservient. A principal may expressly authorize an agent to hire a subservient on her behalf. Where such hiring takes place, the employer-employee relationship comes into being and the doctrine of respondent superior will apply. Example, assume A authorizes B to hire employees on her behalf. Pursuant to this authorization, B hires C. The employer-employee relationship exists between A and C, and not between B and C. Under respondent superior, A is liable for C's torts. That's the principal. A is the principal. Liable for the hiree. The agent's hiree. Implied authority to hire a subservient. Authority to hire a subservient can be implied from the circumstances, including past practices of an employee. Emergency situation. If an emergency situation arises and it is reasonably necessary to hire a subservient to protect the principal's interests, the authority to do so will be implied. Reasonable to achieve result. Under the modern cases where an employer directs her employee to achieve a result, there is an implied authority to use reasonable means to accomplish the task, including hiring of a subservient. So P hires X to lay bricks, compensating X on the basis of the number of bricks laid. X hires a helper Y. Nothing has been said about whether X can have a helper, but X is an employee, i.e., he is subject to P's control. P is liable for Y's torts. No authority to hire a subservient. As a general rule, an employer is not liable for the torts of a subservient engaged without authority. So Sam is hired to drive a delivery truck, but he's busy one day, so he asks a friend George to drive it for him without permission from his boss. George negligently causes an accident and injures Ted. The boss is not liable for Ted's injuries. Employer-employee by estoppel. So we're going to keep going until we get to okay. Another 2 pages. I wasn't expecting that. Employer-employee by estoppel. Even though no employer-employee relationship actually exists, a principal may still be held liable on an estoppel theory where the principal creates the appearance that an employer-employee relationship exists, although no such relationship actually exists. The third a third person relies upon this appearance, the principal may be stopped from denying the existence of a relationship. If the principal is so stopped, she can be held liable under respondent superior. So let's read an example. Assume a shoe repair department in a department store is run by an independent contractor, but the department is run in such a manner that appearances indicate that the operator is an employee of the store. In a tort situation, the store will be stopped from denying the employer-employee relationship. The store can be found liable for the torts of the department operator. This is a reliance situation. If the department store makes the true relationship known to the public by sign, etc., no liability will be imposed. And liability for acts of borrowed employees. An employer may lend the services of her employee to another if the employee commits a tort while performing in his loaned role who is liable. For example, who is the employer? The key issue in determining liability for the employee's torts is whether the borrowing principal or the loaning principal has the primary right of control over the employee. In most situations, the employee remains under the right of control of the loaning principal, and thus he is the only one liable for the employee torts. However, if the borrowing principal directs the actions of the employee, she will be liable for those actions if they are performed tortiously. Let's give you an example. It says P, who directs employees, is liable. Actions, I guess is what it says. Liability for acts of independent contractors. It is important to note that there are situations where a principal may be liable in tort without regard to the existence of the employer-employee relationship. These are situations where, as a matter of public policy, liability for the negligence or wrongdoing of an independent contractor will be imposed on the principal. 1. Inherently dangerous activities. Where the acts to be performed by the independent contractor are of an inherently dangerous nature, the principal will be held liable for resultant injury, for instance, blasting and demolition. And 2, selection of an incompetent independent contractor, knowing selection and negligent selection. If a principal who hires an incompetent independent contractor has knowledge of his incompetence, she will be liable for the contractor's negligence. Negligent selection. If a principal negligently selects an incompetent independent contractor, she will be liable to the injured party for her own negligence in selection. Non-delegable duties. There are certain situations in which a principal has non-delegable duties to act. For example, a land occupier has a duty to keep land safe for business invitees. When a principal delegates such a duty to an independent contractor and the independent contractor performs negligently, the principal will be liable for the independent contractor's negligence. So we enter into like a really big section here of scope of employment. The employer is not liable for the torts of her employee unless the tort occurred within the scope of the employee's employment. If the tortious conduct was in a common sense way associated with the employment, the courts will usually find that it was within the scope of employment. The distinction may be phrased: was the employee going about the employer's business? 3 tests usually are used. 1, whether the conduct was of the same general nature as or incident to that which the employee was employed to perform. Whether the conduct was substantially removed from the authorized time and space. Limits of the employment. And whether the conduct was actually or at least in part by a purpose to serve the employer. Authorization not required. Same general nature as job. To be within the scope of employment, the employee's conduct does not have to be actually authorized. Furthermore, the fact that the act was forbidden by the employer or performed in a manner forbidden by the employer does not necessarily remove it from the scope of employment. There is no easy formula in determining whether the conduct is of the same general nature or incident thereto as that which the employee was employed to perform. In each instance, it is a question of fact. However, serious criminal acts are normally considered to be outside the scope of employment. People are such idiots. Frolic and detour, space and time limitation. And so, finally go back to where we were when we lost a page. Consider the employee's conduct was within the time and place of the authorized employment. A detour, a small deviation from the employer's direction, is within the scope of employment, while a frolic or major deviation requiring a substantial departure from employment is beyond the scope. Once it is shown that the employee has left the scope of employment, there must be a proof of return before the employer will be held liable for the employee's tort. The employer's ownership of a vehicle driven by the employee at the time of the employee commits a tort does not automatically impose liability from the employer for the tort. Motivation to serve employer. Finally, consider whether the employee's conduct is actuated, at least in part, by a purpose to serve the employer. You need more food. Somebody needs more food. Finally, consider whether the employee's conduct was actuated at least in part by the purpose to serve the employer. Passengers. There's more than one gear there, fellas. Oh, they're just starting. Okay. Passengers. The employee's invitation to passengers, unless expressly authorized by the employer, is generally held to be outside the scope of employment relationship, and the employer would not be held liable for injuries sustained by such passengers. Unauthorized instrumentalities. The employer is not liable for torts caused by the use of substantially different instrumentalities from those authorized, for example, those creating a greater risk of harm. And trips with two purposes. If an employee makes a trip with two purposes, it will be within the scope of employment if any substantial purpose of the employer is being served. Intentional torts. Intentional torts are not normally within the scope of employment unless a natural incident of the employee's duties, as where force is authorized, where the employee is promoting the employer's business, or where the nature of work gives rise to hostilities. A principal is liable for the negligence misrepresentations if the agent's actual, apparent, or inherent authority to make statements concerning the subject matter involved. Ratification. An employer may ratify an employee's torts if the normal requisites of ratification are met. In tort ratification situations, pay particular attention to the requirement that the employer must have knowledge of all material facts. And so, should be on the last page now. Apparent authority. If respondent superior does not apply, the principal may still be vicariously liable in certain circumstances if the agent acted with apparent authority. See an earlier section for discussion of apparent authority. This theory of liability is not commonly tested on the bar exam. Most vicarious tort liability questions will focus on whether the principal is liable under respondent superior. Still, it is wise to consider apparent authority as an alternate theory if respondent superior does not apply. Requirements. A principal is vicariously liable where an agent appears to deal or communicate on behalf of the principal and the agent's apparent authority enables the agent to commit a tort or to conceal its commission. This means that for the principal to be liable, there must be a close link between the agent's tortious conduct and the agent's apparent authority. California evidence distinctions has been removed. Civil Procedure California is here, and it's 23 pages in length. And we just read a 14-page outline. So, shall we continue? I think not. I think we'll come back to another recording. How do I end this? And